It's attorney Jason T. Brown from the Whistleblower law firm Brown LLC. One of our listeners was gracious enough to ask a question in the comment section below, and as indicated, we were going to try to answer questions in which people left and or asked us to do a video about. We do not give case-specific advice. For that, you would have to call the law firm or another whistleblower law firm. And we are going to sanitize the way the question was asked and afterwards delete the initial question because we don't want anything to be too specific. But in summary, the question was, can you do a video regarding free housing in exchange to bill Medicaid? Also, the patients referred to the treatment program are also referred to a different facility that the same owner owns. And the second entity as well bills Medicaid for treatment services. So let me indicate right on the onset, there's probably a ton of other facts and information that we need to know. And the advice I'm about to give cannot and may not be relied on. But let me give you a quick overview of things I hear when I hear an issue along these lines. If a patient is receiving something for free, when it normally and ordinarily should be charged for, and it's a horse trade for Medicaid services, if that's in fact what's going on, the first thing I think about is the AKS, the Anti-Kickback statute, a component under the False Claims Act. Now, if you give something for value or above fair market value in exchange for Medicaid, Medicare patients, or quite frankly for other things as well, but typically you see it rear its head in Medicaid, Medicare type of circumstances, it could be a violation of the AKS. The AKS is a pretty strict statute at times. The AKS has both criminal and civil consequences potentially to it. So if you, for argument's sake, are the employer that's doing this, you really want to speak with a defense firm or a health regulatory firm to understand whether what you're doing is lawful, and if it's not, how to clean up the mess. The second part of it is referring to a derivative company in which the owner has an interest in. And that's oftentimes confused with the AKS and the kickback statute, but in fact is a different statute, which is the Stark Law. And the Stark Law prohibits under federal law, when you're taking Medicare or Medicaid funds, self-dealing. And self-dealing is steering patients pretty much exclusively, although it doesn't have to be 100% hit rate, but steering patients towards an entity in which the primary referrer has an economic interest in the derivative agency and fails to disclose it in the proper manner, fails to give the patient the right to have all these different choices or educate them about their different choices of other providers they can seek. So that as well could be a violation under the False Claims Act. That as well can have criminal consequences. So going back to what I indicated earlier, if it's advice for an employer about what to do, you really need to speak with a defense firm, not our firm. We don't do whistleblower defense. We don't do structuring. When I say structuring, we don't give guidance to healthcare practitioners about how to comply with the law. We represent the whistleblowers, individuals who want to blow the whistle when the misconduct, if there is misconduct, they want to ascertain, and if they understand there's misconduct, to educate individuals about what their rights are. Hope I answered your question in part. I thank you very much for listening. I thank you for taking the time to write the question. After we post this video in reply to your comments, we're going to delete your comment because it was a little specific. And feel free to give our office a call. Thank you, everybody, for listening.